in, if you're tuning in, and if you're watching the replay, thank you so much for coming to watch. This is Batok with Ola. My name is Mujola Olua, and tonight I just want to talk about witness preparation in Nigeria. Witness preparation for trial. I feel like I've done a video where I talked about this, but I want to talk about it again. In another live session, we're going to be talking about client interview and counseling. Like I have said, when we had our guest, the last guest, Miss Rita, I said that we're going to go through a number of topics: witness preparation, client interview and counseling, and we're going to do what's the other one? Foreign participation in businesses in Nigeria. So, witness preparation for trial in Nigeria. And I've not put anything down actually, so I'm going to be talking from my own experience, so far. And I hope that you're looking dark. Why are you looking dark? Let me see. Okay. So I think it's better that way. So, witness preparation in Nigeria, and I'm going to talk about my experience. Like I've mentioned, a few times, I'm going to say it again that, I have been a criminal defense lawyer, I've been a prosecutor, I've been a claimant, and I've been a defendant, defense counsel and claimant counsel in civil matters. So, I've been through the whole works, in record time. So I like to talk about my own experience, and I'm looking forward to a much more diverse, practice, as I move on. As you must be aware, I have a consultation, an online, a virtual consultation service, that is attached to this YouTube. I still had a consultation with someone yesterday, so I hope that you people continue to use that service. And I also have a law firm, that caters to all legal challenges as the need may arise and as my specification or specializations or practice areas may afford. And so let's talk about witness preparation. What is witness preparation? It's basically you getting your witness ready for court, for trial. You need to get your witness ready. The cardinal rule that I would give in witness preparation, if you are joining live and you want me to give a shout out to you, you could just put something in the chat box and I'll do that. Thank you so much for joining. Those that have joined, I can see, that some people have joined. Usually when I'm doing lives these days, I don't expect that people will join. I just expect, let me put this out there and then people watch later. But I know that as we go on, people will join, and I appreciate people that join as well. So witness preparation is very important. I said there's one cardinal rule, and that rule that you must always have in your pocket, at the back of your mind, in the front of your mind as a lawyer, is that you must not be hearing anything from your witness in court before the judge for the first time. Very important. Make sure that whatever your witness is going to say in court before the judge, that's going to be put on record, is something that you have heard before. Either you have front-loaded it in their witness statements on oath, or it is in their statement before the police if it's a criminal matter, or it's something that both of you have rehearsed or agreed that this is that must be said or put before the court. Now, when I say rehearse, I do not mean prepping your witness to tell a lie, because lies always come out. There's no way you're going to prep your witness to tell a lie. If the other counsel is very smart, they will bring out the lies. And when you're lying, it's difficult to cover up your tracks. Some things will just get through the cracks. So very important. Witness prepping does not mean you're teaching your client or your witnesses to lie. Rather, it means you're getting them ready for court, such that whatever they're going to say to the court will be in your favor, in the favor of your case before the court. That is witness preparation. Very important. Getting your witnesses ready for trial. So looking at it, I've prepared my first law firm. Did I prepare any witness for court? Yes, in a civil matter. I remember that we had filed a claim for a man. He had shipped some things to France, I think, to his maybe girlfriend or partner, and the delivery company did not deliver it, and you know, they were having back and forth, and they had, been putting him off for about a year. They did not deliver, they didn't refund. His partner didn't get the goods in France, he didn't get his money in Nigeria or the goods back. So he sued them, and we were representing him in that matter. So I was preparing him. It was his first time going to court, and he was very curious and excited about it. So yes, I remember that. I remember that at my second law, the other matter, it was ongoing. So it was the cross-examination that I started with. I think I've talked about that, on the channel. And what else? At my second law firm, yes, I prepared witnesses for trial. I remember we had this receiving stolen property. What's the noise about now? Sorry about that. I remember we had this receiving stolen property matter, and um, in that matter, sorry guys, I hate noise. I don't know what the noise downstairs was about. Oh dear God. Sorry guys. So I remember that we had one receiving stolen property matter, and then we were going to court. We had talked, I also prepped the witness a bit. Okay, okay, David, I'm going to get to that, but let's sort out what we're talking about in this video. Hi David, thank you for joining the session. So it was a receiving stolen property matter, so of course I had to prep the witness too. Yes, and then in several other matters, armed robbery, yes, rape, or plenty of criminal matters. And I've prepped different types of witnesses: civilian witnesses, and law enforcement. I remember we had a forgery matter where I had to prep the DSS officer that I was putting in the dock, for my lead counsel to examine, and the other party to cross-examine. So his superior uh, told me that that would be his first time in the box, so that I should help him get ready well. So I remember we had to go over, what is evidence or his testimony, about 2 or 3 times, and then he even said, okay, test me now, and all of that. I also remember there was this armed robbery matter, where his bike was stolen. I had to prep him, for trial. I'll get to why I'm mentioning these things as we go on. I've prepped different, police officers, as IPOs, investigating police officers in criminal matters. I remember also prepping my client in a labor dispute, at the NIC. I had to, after going over, our his testimony, together. This is what you say, this is what's important, and all of that. I had to now type out the important things, the likely questions and the answers, and send it to him, go over it. So how do you go about witness preparation? The first thing is to, as a lawyer, familiarize yourself with the case to the best of your abilities. So get all the facts straight. Sometimes clients withhold information. You as a lawyer must know the questions to ask and how to ask them. You will not get all your facts from a client in one sitting. Maybe the client has told you a story now. Oh, my boss fired me, this and that. He didn't pay my severance, or he didn't pay my last salary. You have written, a letter of demand. By the time you now say, okay, they didn't comply with the letter of demand, let's go to court. And then you're preparing your claims and the witness statement on oath. By the time you begin to question your clients once again, you realize that sometimes you're getting fresh facts that did not even come out at the time you were writing a letter of demand. So it's important, have genuine and relaxed interactions with your clients, such that you elicit all the necessary information from them, so that they are not withholding something because they think, lawyer will castigate me, or lawyer will not understand, or maybe let me keep this. Also, you need to be honest with your client. Don't put up a front that you can manipulate the court to your client. If not, the client will start manipulating you so that you can manipulate the court properly, or they might leave out some part of the information. It's important for you to build trust such that the client will tell you everything that you need to know. That's the starting point. And when I'm saying clients now, I don't mean the claimant or uh, the defendant alone. It could be their witnesses as well, all the witnesses that you need. So it could be eyewitness, it could be an officer of the law, it could be the direct victim, either in the criminal matter or the civil matter. So it could be any. It doesn't necessarily have to be the defendant or the claimant, as the or the nominal complainant, as the case may be. So if when you have established trust, then elicit all information, all the necessary story and everything. Thank you for those that have just joined. And after that, the next thing is for you to decipher what information goes before the court and which one stays out of court. Very important. If someone says, for instance, that, okay, let me use, maybe you are a defense counsel, your client has been accused of armed robbery. Now they have an alibi. They are telling you that as at the time that this robbery was committed, I was with my friend in so place. We were doing so and so. I was not even here. Now it could be that what they were doing at that time is another crime on its own, maybe another offense on its own, or something that is just not good, for public information. You must find a way to uh, present their alibi in such a way that the focus does not shift to what they were doing, which is also wrong or inappropriate, but rather the alibi supports the crime that they are being accused of at the moment. Very important. You must fix priority where priority belongs when you're deciding, prepping your witness. So after you have decided what facts goes before the court and you're filed, we call it front loading. You have front loaded all your information before the court. There's a cardinal rule of trial or examination, and that is why do I keep saying cardinal rule today? That is that whatever you want your witness to come and testify or say before the court, whatever evidence you want to present before the court, you must have mentioned it or laid a foundation for it, in your originating processes. Originating processes differ, for a criminal matter, that'll be your charge sheet as the state, or the prosecuting authority. That'll be your charge sheet, your list of witnesses, and the proof of evidence that you're filed in the matter. As if it's a civil matter, now it will be your statement of claim, your witness statement on oath, and other supporting documents, affidavit in support, every other thing that you're putting before the court. So you must make sure that the thing that you want your witness to prove or to testify to before the court, those facts are already contained in your originating process. Is very important, because you cannot go on a wild goose chase during trial. If your witness is saying something that has no basis or connection whatsoever to what you have filed before the court, the other party would object, and the court will uphold the objection, because that's like introducing fresh facts, and you cannot introduce fresh facts at the point of trial. All your facts must be front loaded. Very important. So now you have put your documents before the court. It's trial time. I suggest you prep your witness before, after you have filed. You go over what you have filed with your witness. Then a day to the trial or 2 days to the trial, you go over it again with your witness. And then on the trial date, if your matter is not coming up early, you could step out of court and go over each witness's testimony with them again. Very important. So how do you go over it? For instance, let me give you the example of the robbery incidents. This man, his bike had been robbed, and he had given a statement to the police. So when these when the defendants were arrested by the police, they arrested them in connection to a series of robberies that had resulted in the stealing of or robbery of several items, including motorcycles and whatnot. So this man had given a testimony to the police. That's why I found the statement in proof of evidence. I called him, he came, and then I prepped him. So when I prepped him, now he could not identify, the defendants, when I pointed them to him, I said, can you identify them? Do you know them? All these things. It was on trial day too, but before our matter was called. So sometimes you see some lawyers stepping out of court, coming back in, making some whisperings. They might be prepping their witness for trial. So he said he couldn't identify any of them. That either an ID parade was not done. It's been a while. Either an ID parade was not done, or it was done and those guys were not part of those, in the parade on the day the ID parade. Yeah, an ID parade was done. He said that after I had given statement, some months later, the police called him that they were doing an ID parade and he should come and identify those who robbed him, because they had robbed him at about 11 p.m. at night. He had picked them up as passengers, then they had robbed him with weapons and drove him off the bike and drove the bike away. So he could not really identify them. So what did I need to get him to do at that point? The idea or the fact that you cannot identify them must not come out of your mouth when you're giving your testimony. Now, I gave him the statement to read again, because sometimes, especially in criminal matters, the distance between the time when a witness or a nominal complainant gives a statement and the time when the matter is coming up for trial, it takes a while. Even for police officers, sometimes when we call them and I say that, oh, in this matter, they don't remember until you tell them the whole story of what happened in the matter. So when they come to court on the date, they ask you to please give them the case file so that they can quickly go through it, because they investigate a lot of cases and they are transferred all over the country at any given time. So sometimes they cannot even remember the particular case you're talking about and what their investigation revealed. But once they get the case file, they read it up, then they know what to say. So for police, you really, once they read their case file, they are good. So you can't really be telling them this and this is what you see, unless they are compromised. There was a time we put an IPO in the dock for a murder charge, and he kept giving evidence towards unlawful association, which is another charge, instead of the murder charge. So it was as if maybe he was afraid of those gang members, or something had happened in the mix, and he wasn't leaning towards the principal charge, but it was giving more evidence leaning towards the secondary or the second charge or the later charge. So for the robbery guy, I gave him a statement to read. The statement basically said that he took the bike on hire purchase from a certain person. He was paying, he was using for commercial purposes, and he picked up these guys as passengers at a certain, he couldn't remember the date as well. So or the day of the week, but he could remember the time that he was robbed and where he took them to from where he picked them up. So the purpose of prepping him is to help him get those things straight. So this is the date now. So let him quickly memorize it, because if he goes into the box, the other party, the other counsel will question him to prove to the court that his testimony is inconsistent, and as such is not a witness of truth, or is not a reliable witness. Meanwhile, the actual situation is that this has been about a year or two after the incidents happened, before the matter got to trial. So how do you expect him to memorize those things? Some people are so traumatized that they remember every little detail. There was a time we put this kidnapping witness in the box, and she remembered every little detail, even though they had been blindfolded, and taken, through a long journey. She kept on describing by landmarks, all the places they passed, when her leg hit a stone, when she could hear running water, to show that they were passing by a river. She did excellently well, but not many people, because I think that she was traumatized by the incidents, but not many people will have that ability. Also, if people are traumatized, it could be converse. That is, the trauma may make them forget. If someone has been raped, for instance, they may not recall or may not be able to bring themselves to say some things. So it's important to go through the testimony that they gave at the point of the incidents, so that you get all your facts straight before the court. So I helped him get the date straight, the time and all, and then I said, okay, so you're telling the court that this and this happened. After that, you dropped them. When it was time for you to drop them, they then accosted you, they didn't pay you, they threatened you with so and so weapon, and then they made off with your bike and the key. So that is what you know. Now, I think you wanted to say some other things, but no, this is where you stop. So, for instance, I remember that in another matter too, it was a labor and employment matter, and the witness was telling different stories. Oh, this and this is what happened. You don't need those stories. The things that we put in your witness statement on oath, repeat them to the court, near verbatim, if not verbatim, but at least let it be consistent. If you go fishing too much, the other party will come in and plant doubts in your story. So it's important for you not to allow your witness, to go to town and then just keep saying all manner of things. If someone has been poisoned, for instance, maybe this person, maybe someone and someone, maybe they were friends, then they fell out, and then the one person poisoned the other person's drink. Maybe this person will be saying that they will poison you, they will poison you, and then they eventually poisoned you, and then the case goes to trial. Now, when you're prepping such a witness, it's important, go straight to the point. They had threatened at so and so period, and then they carried out the threat, and so just go straight. Don't start saying, oh, on the so date we fought, when we now fought, I now said this to her, she now said this to me. Things that are not in the witness statement, don't put it before the court will even halt you, or the other party will halt you and say that that's not the case. So what do you do when you're prepping your witness? Make sure they stay within the precincts of what is in the witness statement or oath, and make sure that they stick to facts, not opinion, facts. On so date at so time, this and that happened, I did this person did that, this thing happened, so and so. Then because the other party will also cross-examine them. When the other party is cross-examining them, you must also prepare your witness not to get riled up. So what I would normally do is, I will ask, after we've gone over the witness statement on oath, I will then ask questions as if I am the lawyer and I've put them in the dock. Of course, you have, very important, you prepare them for out the trial will open. They put them in the box, they'll give you Holy Bible, Holy Quran, then you swear on that. For instance, if you're putting a witness that is averse to swearing, and you don't prep them, how will you know that they are averse to swearing? They'll just get into the court and create a scene. When the registrar gives them Holy Bible or Quran, they say, I don't swear, I don't want. There's provisions for people who don't want to swear to affirm. So you need to know, do you swear or not? You're going to be sworn on Holy Bible or Holy Quran. Which one do you want? When they say, okay, I don't swear, okay, you're going to be affirmed. So the registrar will say this, you say it after the registrar. So you take them through that. Then the WH questions, they will ask you, what is your name? Where do you live? And what do you do for a living? Those three things. So you get it through. So for instance, if a witness was living at number 2, Felele Avenue, and that's what you have put in the witness statement on oath, or maybe that is what they had given to the police at the time that the matter happened. When they are going into the dock, maybe they have now moved to Lagos. It is not their place for them to now be, when you now ask them in the dock, what do you do, where do you live, they cannot now say that I live at number 10 Shogotedo, Ajah, Lagos. No, they will say that Felele address, because that is what is in the witness statement on oath. That is what is before the court. Because you cannot at that early stage begin to introduce inconsistencies into your testimony. So you take them through all those preliminaries, and then you ask them questions as if they are already in the dock. So after then you teach them to look at the judge, so they won't be looking at you or making eye contact with you. Very important too. Some lawyers don't take their witnesses through these basic things, and they just bring out the fine parts or aspects of your practice when you do them or pay attention to them. So now we've put the witness in the box. Witness, tell this honorable court and I will not be acting as if I know you. So don't be smiling at me. Or if I ask you, for instance, witness, tell this honorable court your name. It's not the time for you to say, lawyer, don't you know where my name again? No, we are not friends now. It's counsel and it's witness in court. So you take them through those, and then you ask them questions. Then I'll now ask you, what do you know about this matter? So After I prepped that my honorable witness, and I said, okay, now I asked him his name, what he does for a living, where he lived, and then I said, what do you know about this man? Do you know why you're here today? Look in the dock. That one will be for when your witness can identify. You can say, look in the dock. Do you know any of these defendants? If he says I know them, then you now say what happened. If it's a rape matter now, the rape victim will most likely, not in cases, know the defendant. So you say, well, do you know the defendant? How do you know the defendant? Then they will start telling their story. Because in examination in chief, there's a video, a comprehensive one on examination in chief, cross examination, and re-examination on this channel. Please look for it and watch it. Very important. So in examination in chief, you're not allowed to ask leading questions or to butt in too much. You need to let them tell their story. So it's important. Then you say, okay, what happened on the so date? So when he was saying that he could not really remember the date, I said, no, don't worry. This is the date. Look at it, try to memorize. But if you cannot remember, I'm going to ask you what happened on the 10th of February 2019. So once I ask you that, you know that it's time for you to tell us about the robbery day and how it started and ended. So you already agree with your witnesses what the cue will be for them to say certain things at certain points. After you've gone through your own part, you go through the other party's part too. That okay, so the other person will now ask you this. Witness, you will agree with me that you are not a witness of truth. You will agree with me that you have been lying to this court, not those specific questions, but you now start asking them uh, how the other party would ask them with the same antagonistic, you know, disposition that the other party might likely assume in court. You assume it outside of court. You assume it in your law office ahead of time. You preempt the other party. Ask likely questions they might want to ask in the matter to plant doubts. So sometimes when you're doing this and this happens, you find out that your witness is falling for, the doubts you are creating in their story. And then you tell the witness, is this how we are going to win the case? You say, if they ask you that, you don't say this, you say that. That is, that's prepping. That's the essence of prepping. You're not teaching them to lie, but you're teaching them to stick to the favorable facts of the case. So when they say this, don't follow them. They are trying to take you on a journey out of course. Stay the course and say this or answer like this instead. Very important. But if you have prepped your witness to lie, the other party may surprise you. You don't know what they will come up with. You can only preempt. You might not be accurate. So they may have a way of fishing out, the truth. Also, the court is allowed by the Evidence Act 2011 to ask witnesses questions suo motu. That is, the court on its own can ask the witness some questions that will be on record and they have to answer. So you can preempt that too, that the court might likely ask you, if this person asks you such question, reply like this. But in case Milord can say that, answer the question, witness, this is what you should say and this is how you should answer this. So very important. If you notice that your witness is loquacious, prep them like 3-4 times. Assure them that whatever they say can make or mar their case. Please go over their case with them and trim off their excesses before they get into court. If you notice that your witness is cantankerous, please sit them down and talk sense into them ahead of time. If you notice that your witness can be petty, can be difficult, can be aggressive, can be given to anger, please sit them down. This is all part of prepping. Talk to them. The other counsel is not your enemy. Of course, they are your enemy in a way, but they are not your enemy in the literal sense, such that you cannot, snap at them in court. So, sometimes the other counsel will be asking your witness a question, and then the way they will respond, it will be like sassing them, or being sarcastic or angry or rude or condescending. Sometimes the other party will then appeal to the court, please, or appeal to the court to tell you to caution your witness, and doesn't look good on you. And sometimes even the other party can seek the protection of the court if your witness is very aggressive or is threatening, because sometimes witnesses will be threatening the other lawyers. So lawyers go through a lot. But as a lawyer, it's important for you to prep your witness ahead of time, not just for your own case, but for the other party, so that they behave themselves and conduct themselves in a way that is likely to favor your matter. Also, the other party might be trying to rile up your witness just to prove to the court that they are not probably sane, they are not reasonable, they are difficult, or they have done what the court is accusing what the other party is accusing them of. So you need to go through all the motions with your witness to ensure that they do not fall for any of the tricks and tricks of the other counsel or the other party. Also, the same thing goes for the other party in a matter. So this is what witness preparation is about. It's you basically prepping your witness. Then you tell them when the matter is done, you don't walk out of the dock on your own, and we apply to the court for your discharge, then you can walk out. Also, if you're tired, you don't just sit down. Even if there's a chair in the dock, you don't sit down in the witness box. Rather, why do I keep saying dock? Dock is for criminals, but they take them out of the dock and bring them into the witness box. Everybody goes into the witness box when they want to testify, but then if it's a criminal matter, the criminals go back into the dock. So even if there's a chair in the witness box, your witness cannot sit down except the court permits it. So if your witness wants to sit down, you need to ask the court permission, or the court needs to permit them expressly to sit. Very important. Whatever they want to do, even if they want to step out to urinate or anything, once they've been sworn on oath, they need to comport and conduct themselves responsibly before the court. Some of these things help your case. The mien of your witness, the courage of your witness, the way your witness answers questions. Also, if your witness will be needing an interpreter, it is at prepping stage that you will ascertain for sure. It could be a witness that speaks English, or maybe broken English or pidgin English, but by the time you start prepping them, asking them likely questions from you and the other counsel, you will realize if their level of understanding and speech of the language, because English is the language of the court in Nigeria, you realize or recognize or decipher if it is sufficient or if you would need to ask for an interpreter for them. Very important. So it will also, if your witness is a stutterer, for instance, it's prepping stage that during prepping stage you'll be able to understand how far they can go and what their abilities are, so that you can notify the court, so that the court will make some certain allowances for them. Very important. Prepping is very important. Remember the cardinal rule: do not go to court to hear anything for the first time from your witness. That means that you must have agreed on all fronts and prepped them such that whatever they are telling the court, they have already told you, you've already heard it, you've already agreed on it, and it's most likely already before the court or in support of what you have already put before the court. Very important. These are things that I wanted to share. If it means, typing out what they will say, or having them go through their witness statement on oath ahead of time, it is better. It is better. It's important for them to know what to cut out, better for them to know the important things to include, so that they don't leave those things out, and to cut off all excesses. So these are things that I wanted to discuss. I hope that it is helpful. I will see you in my very next video live. Don't forget to subscribe. Don't forget that if you need a tailored legal consultation, you can book a paid session with me. But if you have a general question that will benefit other people, you can always leave them in the comment section. Let me quickly get to this. David asked a question. He said, after plaintiff has filed his application for direction, what next? In a situation where plaintiff does not have a lawyer in Ghana court. Okay, so my specialization for now is Nigeria. So we don't have application for direction in Nigeria. I'm not certain what that is. But if you're saying that if plaintiff does not have a lawyer and then he filed an application for direction, I'm not certain what an application for direction is, and if it's possible for a plaintiff to actually file it without a lawyer. So, but I'm willing to do some research on it, and I may come back to drop you an answer in the comments. I hope this comment is public and will not disappear once I close this live. I'm still learning my way around live sessions, but I will see you in my very next session or very next video. Don't forget to watch the shorts as well. To-dos.